Constitutional Court that securitising and exchange commission lacked jurisdiction. Also, our third point is that you, by eliminating the shares, you also eliminate the control of the shares as well. Fourth point is carried out unjustified investigation and threats of prosecution as well. And the fifth point, being able to manage second types of shares because they will then transfer it.
So we'll proceed to the other articles.
Yes, please.
I'm going to address Article 4, subsection 2. I'm going to briefly run over the facts just to bring everybody up to speed. On the 14th of June 2006, the claimant acquired 5,339 shares. Also at this time, he signed the share sale agreement. On the 15th of October 2009, the court ordered the termination of the share sale agreement. Also, they transferred the 5,339 shares to the Minister of Economy, absence of any compensation. In addition to this, on the 2nd of April 2009, the claimant's business was disrupted by a court order that prohibited the foreclosure of a mortgage. We would submit that because of the respondent's conduct and acts, our claimant was treated unfairly, contrary to Article 4, subsection 2, which states each contracting party shall ensure fair and equitable treatment within its territory of the investments of the investors of the other contracting party. The standard of a fair and equitable clause is based on the object and purpose of the bilateral investment treaty. This can be found in the preamble, which states that it is intended to create and maintain favourable conditions for investments by investors of one contracting party in the territory of the other contracting party. To assess the standard of fair and equitable clauses, we will look at the case of LG and G International against Argentina Republic. Would the tribunal like the reference for that case?
Would the tribunal like the reference of that case?
Yeah, no, that's fine.
Well, in that case, at paragraph 12, it was stated that an investor should be afforded broad objective protections and a stable, predictable environment. We shall submit that the conduct and the actions of the respondent, the Macedonian government, fall well below these standards, and therefore they should be held in breach of this article. My colleague will now address the other articles that have been breached.
Okay. I'm going to talk on Article 12 of the treaty which has been breached. According to Article 12, the respondent failed to observe its commitment to the claimant. And I think Article 12 says that every party to the contract shall observe the commitment it entered into with respect to the investment contract. Given a rundown of the fact, the government offered to sell the Argent shares belonging to the Macedonian Pension Fund for a public tender. The Swiss Holding Limited won the tender and acquired these shares. And this was the second tranche. And a share sale agreement was signed. On the 20th of January 2009, the court had granted the ministry's request for provisional measures and thus restricted the claimant's use of the second tranche, which I'd say is a lack of observation of commitment after they had already signed the share sale agreement. And Article 2 of the draft convention on the protection of foreign property states that each party shall at all times ensure the observance of undertakings given by it in relation to property of nationals of other parties. Secondly, On the 15th of October 2009, the court terminated the share sale agreement and ordered the second train to be transferred to the Ministry of Economy without any compensation. And this is still a breach of contract. And I would like to draw us back to Section 11 of the Bilateral Investment Treaty, which stresses on the observance of undertakings taken by the two contracting parties. Thirdly, on the 2nd of April 2009, Swiss Holding Limited obtained another court order that prohibited the bank from foreclosing on a mortgage on the second tranche, thereby disrupting the claimant's business activities. I think this was an illegal act on the part of the government in Macedonia, and we're here to declare that the respondent has caused Swiss Lion to lose control over its investments and thus a breach of the contract, and we would like to claim the compensation. I think I'll give the next person to take over action.
Good afternoon, ladies and gentlemen. My main point under the Apple Tree Global, we're basically representing Swiss Holding Limited, Mr. Peter Charlesy, who has been denied of compensation and a couple of points. Another was, we the claimant allege the following treaty violations by the respondent, most especially the government of Macedonia, has unlawfully expropriated the claimant's second tranche of shares in violation of Article 5 of the treaty. Okay, Article 5 of the treaty, the first draft, basically deals with the draft conversion of the protection of foreign properties. Okay. It states that any breach of the treaty shall entail the obligation of the party reasonable to make full preparation of damages. And because based on that, we believe we have an obligation to get paid for the damages the government of Macedonia caused Mr. Charles, which is the owner of Swiss Holding Company. And in addition to that, they were denied of compensation. The shareholder and the company was denied of compensation. So we have certain claims that we are looking for from the government of Macedonia. And we would like a settlement of £15 million for expropriation and emotional stress, loss of time and money the government had imposed on the company and the shareholders from the following parties or the agencies as follows. The compensation goes as follows. Macedonia government, we are charging and requesting for £10 million, and the State Attorney General, we are requesting for £2.5 million, and the Security and Exchange Commission, we are requesting for £2.5 million as well. In total, £15 million for damages. We would like the respondent.
Okay, now.
Talking about expropriation, I would like to say that generally we acknowledge the fact that expropriation is not prohibited, but then provided that it is for a public purpose, is non-discriminatory, in accordance with due process, and subject to prompt, adequate, and effective compensation. And I would like to pull us to the case of Jolso Factory in Germany versus Poland in 1923, where the judges held that reparation must wipe out all the consequences of the illegal act and re-establish the situation which would have existed if the act had not been committed. Just to add to the fact why we think that we should be paid that sum. Thank you.
Okay, now it's up to the respondents' counsel to respond to that.
Yeah. In a quick reaction to all the claims of the claimant representative, we have to start with a principle of law which says when a contract is illegal, it is illegal ab initio. And on that basis, we cite in the case of Pakin Geye Limited versus Summerfield Stores Limited, decided in 2012. So we have stated earlier that the transaction of the